The Supreme Court just issued a unanimous 9-0 decision that changes the rules for when police can cross your threshold without a warrant. Most headlines will miss the point, but the Fourth Amendment consequences are real, and they reach every homeowner, renter, and gun owner in America. Today on Gun and Gavel, I'm breaking down what the court said, what it rejected, and how this standard will be used against you or for you in the next traffic stop, wellness check, or domestic call that ends at your front door. If you want clear, non-hysterical explanations of rulings that touch your rights, like this video, subscribe, and turn on notifications. Quick disclaimer, this is education, not legal advice. If you're dealing with a search, a seizure, or a shooting, talk to a qualified attorney in your state. With that said, the case started with a phone call to police about a man named Trevor Cassis. His ex-girlfriend reported that he had made alarming statements, including that he might hurt himself and that officers would be harmed if they showed up. That kind of report triggers the emergency label fast, and it sets up the exact question the Supreme Court was forced to answer. How sure do police have to be before they enter? When officers arrived, they saw an empty holster and tried to make contact. They knocked, announced, called his name, and shined flashlights through the windows. No answer. They waited outside for more than 40 minutes. And here's the fact that matters. Several officers on scene reportedly said they did not actually believe anything was wrong inside. Still, they found the front door unlocked, went in, and eventually located Cassis hiding in a closet. When he came out, an officer shot him. A handgun was later found in a bedroom, and prosecutors filed multiple charges. Cassis challenged the entry as a Fourth Amendment violation, arguing that police had time to get a warrant and lacked a sufficient emergency basis to force their way inside. Montana's courts upheld the entry, using a reasonable suspicion-style framework, essentially saying the officers only needed a low level of justification to treat the situation as an emergency. Cassis petitioned the United States Supreme Court, and the court granted review because states and federal circuits were using different tests for the same constitutional question. That inconsistency meant your rights could expand or shrink simply by crossing a state line. At stake was one of the most protected places in American law, the home. The Fourth Amendment doesn't just dislike warrantless entry. It treats the home as the center of privacy, the place where government needs the strongest justification. But the Constitution also recognizes narrow exceptions, and one of them is the emergency aid doctrine, the idea that police can enter to stop someone from dying or being seriously hurt. The problem was that courts had blurred the lines between emergency aid and ordinary criminal investigation, and different judges were applying different thresholds. In simple terms, the Supreme Court had to choose what level of proof the police must have before they step inside. There were three contenders. First, probable cause, the high standard that normally governs searches and arrests. Second, reasonable suspicion, the lower standard used for brief stops and pat-downs. Third, the objectively reasonable basis standard, drawn from cases like Brigham City v. Stewart, where the court recognized that officers may enter to render emergency assistance when the facts, viewed objectively, point to serious, imminent harm. Montana had leaned toward reasonable suspicion. The question was whether that was constitutionally enough. The Supreme Court answered with a clear, unanimous rule. Police may enter a home without a warrant, under the emergency aid exception, only when they have an objectively reasonable basis to believe someone inside is seriously injured or is facing an imminent threat of serious injury. Not a hunch, not a generalized safety concern, not maybe something is off. The court rejected Montana's reasonable suspicion framing as too low, and it emphasized that emergency aid is a standalone doctrine, not a backdoor way to apply stop-and-frisk logic to the front door of a house. The justices also made a point that matters for gun owners. The mere presence of a firearm, an empty holster, or even a report involving guns does not automatically create an emergency that dissolves the warrant requirement. The analysis has to be tied to specific, objective facts indicating imminent injury. And the 9-0 vote matters. When every justice, across every ideological label, signs onto the same standard, lower courts get the message. You don't get to localize the Fourth Amendment. This is the measuring stick everywhere, and it applies whether you live in Montana, New Jersey, or anywhere in between. One subtle but powerful part of the ruling is that the court cared about the reasoning, not just the result. Even if a state court reaches an outcome that seems defensible, it can't do it using the wrong constitutional test. That matters because the wrong test becomes tomorrow's precedent, and tomorrow's precedent becomes a routine practice on patrol. By correcting the framework, the court tightened the exception and forced judges to ask the right question. Did the facts known at the moment of entry give officers an objective basis to believe someone was about to suffer serious harm? Emergency aid is related to, but not identical with, the broader exigent circumstances exception. Exigent circumstances can include hot pursuit, destruction of evidence, or preventing a suspect's escape. Emergency aid is narrower. Its focus is protecting life and stopping serious injury. The Supreme Court stressed that you cannot justify an entry by mixing these categories or by describing a criminal investigation as a welfare check after the fact. If officers are really searching for evidence, they generally need probable cause and a warrant. If they are really trying to stop someone from being gravely hurt, they need objective facts pointing to that danger. That sorting process is now mandatory for every judge. Notice the court's wording. Objectively reasonable basis to believe. Objective means the court looks at the facts, not at the officer's personal motives or after-the-fact explanations. Reasonable means it's judged from the standpoint of a trained officer on the scene, not from a Monday morning quarterback in a quiet courtroom. And basis means there must be something concrete, observable injuries, credible reports of violence, sounds of a struggle, incoherent cries for help, or circumstances that strongly indicate self-harm is underway. Vague unease is not a basis. Neither is he owns guns. The court is demanding that the emergency be anchored to evidence, not anxiety. Imminent is doing heavy lifting here. It does not mean sometime later tonight, and it does not mean this person has a history. It means the threat is about to happen now or is already unfolding. Think active bleeding, a body on the floor, a suicide note next to pills, a child screaming for help, a domestic fight you can hear through the wall, or a 911 call that suddenly goes silent with sounds of violence. Those are the kinds of facts that create an objectively reasonable basis for immediate entry. The court is telling police, if the danger is real, act. If the danger is speculative, get a warrant. In Kasiith, the long wait and the lack of response cut two ways. Prosecutors will argue that silence can signal unconsciousness, suicide, or an armed ambush, and that officers can't ignore credible threats to life. Defense counsel will argue that 40 minutes with no sounds, no cries for help, and officers openly doubting an emergency looks less like imminent injury and more like uncertainty. Under the new standard, those timing details matter because they speak directly to imminence. A true emergency usually escalates, not stagnates. That doesn't mean officers must wait forever, but it does mean a court will scrutinize what changed, if anything, between minute 5 and minute 41. If officers enter unlawfully, the fix is not to resist physically. Courts have repeatedly held that fighting an entry can turn a rights violation into a new criminal charge or a deadly encounter. The fix is legal, a motion to suppress evidence, and in some cases, a civil rights lawsuit under 42 U.S.C. 1983. The new standard gives defense attorneys a cleaner argument for suppression because the judge must focus on objective facts tied to imminent serious injury. but it also gives departments a clearer checklist to defend lawful entries, which is why documentation is going to become everything. Either way, this ruling will show up in body cam footage, police reports, and courtroom transcripts nationwide. Also, watch how dispatchers frame these calls. The words entered into a CAD log often become the first objective fact a judge sees. If dispatch writes suicidal subject with gun, officers arrive primed for crisis. If it's really no contact for hours, the legal calculus shifts. Accurate reporting protects everyone, reducing tragedy, litigation, and community mistrust. Practically, if police come for a welfare check and you are safe, you can reduce confusion by answering from behind a closed door, asking what the call is about, and offering to step outside to talk. If you choose to step out, close the door behind you. That preserves the boundary of the home, and it prevents plain view issues from turning a simple conversation into a search. If you live with others, communicate. A silent house can read like a medical emergency. And if you're the one who called, be precise. Exaggerated language can create an unnecessary imminent harm narrative that results in a forced entry, injuries, and charges nobody needed. So what does this mean for you in real life? First, it means officers can't justify a home entry by saying, "We were just checking," unless the facts support a true emergency. Second, if police show up for a welfare check, a domestic call, or a mental health report, the details matter. What was said, what was seen, and what was documented. Third, your own words matter. If you tell an officer, "Yeah, he's probably fine, but he's upset," you may be weakening the claim that the danger is imminent. You don't have to obstruct, you just need to be careful and calm. For law enforcement agencies, this decision forces immediate training changes. Policies that treated emergency entry like a reasonable suspicion stop now have to be rewritten. Supervisors will need to audit reports for one thing: objective facts. What did officers observe? What did neighbors say? What sounds were heard? What time passed? Did anyone report active violence, screams, blood, or a visible injury? Because in court, that's what will be tested. The better the documentation, the more likely evidence survives. The worse the documentation, the more likely the case collapses through suppression, civil liability, or both. The Cassis facts also highlight a future battleground: mixed beliefs among responding officers. If one officer writes, "I believed someone was in danger," but another writes, "I didn't think anything was wrong," defense lawyers will argue that the entry wasn't objectively reasonable. Prosecutors will respond that the standard is objective, not a vote count, and that reasonable officers can disagree. Courts will have to sort out what those internal doubts mean, and that will shape the next decade of emergency aid litigation. The takeaway is simple. If you're an officer, document what you saw. If you're a citizen, assume the report will become the record. This decision also fits with the court's recent insistence that public safety labels can't swallow the warrant requirement. In Coniglia v. Strom, the court unanimously rejected the idea that police can rely on a broad community caretaking doctrine to enter homes. Emergency aid survived, but it stayed narrow. Put together, those cases build a clearer wall. Officers can act fast when someone is truly in peril, but they can't treat the home like a car, and they can't enter just because a situation feels uncomfortable or because firearms might be present. The Constitution demands more than discomfort. From the citizen's side, remember two things. You can ask, "Am I free to leave?" during an encounter outside, and you can ask, "Are you asking for consent?" when someone wants to come in. If an officer asks to step inside, you can politely say, "I do not consent to any search or entry." Say it calmly. Don't argue the case law on your porch. If the situation is truly an emergency, they'll enter anyway under the exception, and you don't want your words twisted into consent. If it's not an emergency, your refusal preserves your challenge later. For gun owners, this matters because emergency calls and welfare checks often intersect with firearms. A holster, a safe, a case, or a social media post can shift the tone of an encounter instantly. This ruling doesn't eliminate that risk, but it does force courts to demand more than there might be a gun. The officer must be able to point to facts indicating imminent serious injury, not merely potential danger. That difference can decide whether a gun discovered inside becomes evidence or becomes fruit of an unlawful entry. If you carry, train yourself on the legal language of consent, because most Fourth Amendment losses happen through casual cooperation, not force. Going forward, watch how lower courts apply the phrase objectively reasonable basis. Courts will look at the totality, time elapsed, credibility of the caller, visible signs of distress, prior history, and what officers did to verify before entering. Expect departments to emphasize body camera narration because officers will need to capture what they saw and why it suggested imminent harm. Expect defense attorneys to focus on delays, contradictions, and statements like, "I didn't think anything was wrong." And expect prosecutors to argue that the standard is flexible enough for real emergencies, but strict enough to protect the home. Now, I want your take. If you were standing on that sidewalk and you'd already waited 40 minutes with no response, would you call it an emergency and go in? Or would you freeze the scene and seek a warrant? Does this standard give police too much discretion? Or does it finally put a needed brake on just-in-case entries? Drop your answer in the comments and tell me what state you're in, because local culture often shapes how these calls play out, even when the constitutional rule is uniform. That's the core of the ruling. Emergency aid remains, but it's pinned to objective facts and imminent serious harm. Your home is still the most protected space in American law, and the Supreme Court just reminded every judge and every department that exceptions don't get to grow in the dark. If this breakdown helped, support the channel. Like, subscribe to Gun and Gavel, and share this with someone who still thinks police can enter anytime they say safety. In the next video, we'll cover how to handle consent requests during traffic stops and why just being polite can cost you your case.